we invite, in the beginning, we invite the Australian Catholic Bishops Conference, represented by Father Brian Lucas, to present. Welcome to the inquiry.
Thank you, Senators.
Father Lucas. Is it Friar or Father?
Father Brian Lucas.
Thank you. Would you like to make an opening statement?
Yes, thank you very much, Senator. There are a number of issues, of course, that are connected precisely with the bill as it's drafted, and a number of much broader issues relating to the regulation and organisation of the not-for-profit sector. Perhaps if I could assist the inquiry by just focusing on one particular aspect to do with the way the UK Charities Commission operates, and we've made a comment in our submission to say that the approach that it has taken to the public benefit test is problematic. By that I mean it's not fully resolved and it's still very early days. I think what has happened in the way in which the UK Charities Commission has set out its guidelines is that it's moved its understanding of what we mean by public away from what we believe is the proper common law understanding, which is that public is the opposite of private. In other words, if you are engaged in some activity that is of a private nature, that's not charitable. The basis for that, of course, is the very meaning of the word charity itself. Charity, from its origins in caritas and its translation as love. Charity, by its very definition, is about the other. If you do something for yourself, good though that might be, that's not charitable. So charity is about the other, and hence the common law understanding of public benefit was always to disqualify organisations, institutions who are operating purely for some particular private benefit. What I think has happened as the word public has been more broadly understood is that the UK Charities Commission has started to look at the public as meaning everyone. So it looks at questions, for example, of access. There are, I think, from memory, 12 organisations listed on the UK Charities Commission website that have been audited or assessed. I noticed one of them was a Jewish aged care home. That's a very small home, 42 beds, set up for the care of Orthodox Jews. It failed to meet the public benefit test because it couldn't demonstrate that its fee structure gave sufficient access to those who had less means. That's a shift in the understanding of public from providing merely a private benefit to a group that the institution controls to a different understanding of public. So I think that's a matter that needs still some further reflection and understanding, and it's done the same with respect to fee-paying schools, where it starts to measure public benefit in terms of how many scholarships, how much access to playing fields and the like. It's a different understanding of public as they've developed their guidelines. So in that sense, it's problematic. I think also we have the difficulty always of measuring what we mean by benefit and how do you quantify, and that's particularly the case with respect to religious organisations. How do you judge and measure benefit? And whether the church is left open for public worship or whether the particular religious institution has a different worship structure doesn't seem to me to be the point of the test. The point of the test is whether or not the benefit is open in the sense that it is non-private. So I make that observation because I think if we are working towards a more comprehensive regulation and structures of accountability for the not-for-profit and charitable and religious sector in Australia, so some clearer thinking about just what exactly we understand the public-private distinction to mean, and what expectations we have of organisations. So that Jewish home that looks after Orthodox Jews is in my view, a charitable institution because it's looking after people that are beyond simply a private activity. The fact that those people need to be people of some means because a small home requires a fee structure that excludes poorer people in my view, doesn't exclude it from being charitable. Caring for rich people is as charitable as caring for poor people, and there will be different organisations within a broad section of the community, and we will need to do both. So I make that just, Senator, as an opening observation to take that particular point a little further, because I think it does provoke the need for some further discussion and reflection.
Thank you very much, Father Lucas. There are now charities commissions in a number of countries, the common law countries that are sort of countries very much like Australia, including the United Kingdom, Scotland, Ireland, New Zealand. What has been the experience of the mainstream churches in those jurisdictions under charities commissions administering a public benefits test?
I mean, the experience has been mixed, and obviously different institutions and different organisations will have their own particular experiences. There's been, as far as I'm aware, no significant outrage, if I could use that rather extreme word, but there would be particular organisations that in particular instances have had some difficulty. In particular, there is the question, and this varies from country to country because the reporting requirements, of course, are different, but there is the question of the cost associated with the level of reporting that may be required in some places.
But you would have to bear those costs anyway in having accounting done and annual returns prepared, wouldn't you? The difference is that
it depends on whether or not
data is made public.
It depends on whether or not those reports that are already being prepared can simply be delivered, or whether different sets of reports are required. When we have, Senator, if I could digress just for a moment, an enormous problem in this country with the level of reporting that different parts of the charitable sector are required. The 19 most significant Catholic social welfare organisations in Australia administer in excess of 600 government contracts, all of which have to be reported separately and differently.
Yes, that's an interesting point to make. In your submission, you talk about the United Kingdom Charity Commission as problematic, having reserved, which is something I asked the UK group last night. You may have heard that. I read this paragraph. Having reversed the presumption of public benefit, it is sought to develop criteria to measure public benefit. For example, with respect to independent fee-paying schools, it assesses public benefit by reference to matters such as community access to facilities and availability of scholarships for those who have insufficient means to pay the fees. Such criteria are arbitrary, and you say how much access, how many scholarships. So that would suggest that the mainstream churches have had some difficulties in the United Kingdom, would it not?
Not so much the faith-based church schools, but the schools, and these are on the UK Charities Commission website, the schools that were knocked back were the fee-paying independent, or what they would call public schools, who, because of the way that particular school was organised and structured, failed to meet the test as the UK Commission set it out. And it comes back to my point, I think, that way of understanding what we mean by public, in other words, access to a large number of people or a particular group of people, misses the point of what the public benefit test in the common law was originally intended to explain.
Very well, thank you. Senator Cameron.
Yeah, thanks, Father Lucas. In terms of schools, my experience of Catholic schools was in Scotland, and it's a much different proposition than here. The Catholic schools are fundamentally funded by the state in Scotland, and they've got different curriculum, so it's not apples with apples comparing what's happening here. So I might just ask you, in terms of the public benefit test and the example you gave in the UK, if there was a group of merchant bankers set up a retirement home and say this is a charitable organisation, does that meet the test?
It would depend on who the merchant bankers, what the purpose of the group of merchant bankers.
To look after burnt-out merchant bankers.
Well, if the group of merchant bankers establish an organisation that meets all of the not-for-profit tests, and it is open to a wide range of burnt-out merchant bankers, and not simply the few merchant bankers who've set it up and run it and control it, it could well meet the test.